Good afternoon and welcome to the new Civil Liberties Alliance. Today's Lunch and Law program is entitled SCOTUS Restores the Seventh Amendment Right to a Jury Trial. How far does the new ruling reach? And here to discuss that topic are three very well-informed appellate litigators who have been tracking the SEC v. Jarkesy case closely and were involved in briefing that case as amici. And first we have Rich Samp, a seasoned constitutional appellate litigator at the Washington Legal Foundation and here at NCLA. He is now retired, but is a member of the NCLA Board of Advisors. Next to him, we have Peggy Little, senior litigation counsel here at NCLA, who has really been on the Jarkesy case for a long time now, including back at the Fifth Circuit and working with on the moots and in lots of different capacities on the case, and has good inside information there. And finally, we have Michael Showalter, who's an appellate litigator at the Wiley Ryan firm here in town and filed an amicus brief in the case as well. So let's jump right in. Peggy, maybe I can start with you to remind our audience what the holding was in this case, and we can go from there.
Sure. Well, the holding does restore jury trial rights to those charged in administrative proceedings in which a penalty is sought by the government. And that's important, and it's a really groundbreaking restoration. I don't want to say it's something new because it really isn't. As Justice Roberts, who wrote the opinion, said, it's a straightforward application of law. It also cleans up the public rights doctrine. But for me, the most exciting, the most important, and the most gratifying part of the decision is that it is actually decided on two grounds, both Seventh Amendment and Article 3. And this gets totally glossed over in the various press about this, but it is not just a Seventh Amendment decision.
I'm going to have to change the title of the lunch and law today. So.
Well, yeah, and I had to read this 3 times to be sure. I was not saying something startling or inappropriate, but the decision by Justice Roberts opens by saying an Article 3 court must decide these questions, and then with a jury if the Seventh Amendment applies. He goes on to say, under the basic concept of separation of powers that flows from the scheme of tripartite government, the judicial power of the United States cannot be shared with the other branches. He also says the other branches of the federal government cannot confer the government's judicial power upon entities outside of Article 3. He then goes on to talk about the Seventh Amendment question. But in case there's any doubt that this is about both, he repeats it twice in the opening opinion, and Justice Sotomayor in the dissent admits as much. There are 2 key constitutional provisions at issue here. One is the Seventh Amendment, which preserves the right of trial by jury in suits at common law. The other is Article 3's vesting clause, which provides that the judicial power of the United States shall be vested in Article 3 courts. So this is a far more, has far more reach, excuse me, I'm getting over a cold, and has far more influence upon how agencies will be able to charge Americans than just the Seventh Amendment question. And the reason this is so exciting for NCLA is I believe we are the only amicus that briefed that vesting issue. The other brilliant thing about the vesting issue, it makes the other 2 certified questions irrelevant because they didn't treat it as a delegation question. It just said, no, you have to go to Article 3 courts, and the various other due process issues or even the removal question is irrelevant because you're not before an ALJ. And so that clears up a lot of the mystery, I think, of why only the jury trial issue got argued at the argument and why this appears to be a Seventh Amendment decision. But it most decidedly is not just that. It is a vesting decision. And for that, and because of the way we framed it in our amicus with Philip Hamburger's great guidance on this question, this is a really important Article 3 vesting decision and should be understood as such.
Well, that's very interesting. One of the things I know we've been saying at NCLA for a while is that Congress doesn't have judicial power to begin with, so Congress can't delegate judicial power to the executive branch, and this decision is very consistent with that. The last thing that Peggy said anticipated my question to you, Rich, which is, why didn't the court reach the other question in the case? I mean, I think that there were three questions that were certified in the case. I think a lot of people thought that the non-delegation question wouldn't be reached, but I think maybe the majority of the folks that I talked to really thought that there was a chance the court would only decide the question on too much removal protection for ALJs at the SEC and might not even reach the jury trial rights question. I'm glad that they did, but do you have any thoughts on why they still haven't reached the protection for ALJs question?
Well, the protection for ALJs question was really, to some extent, already decided in some prior cases. ALJs have a double layer of protection, and in past decisions, the court has said that is too much protection, and it interferes with the right of the president to control what the executive branch is doing. The problem is, what kind of remedy do you impose for that violation? And there is a Supreme Court decision called Collins, which seems to suggest that, as far as the Supreme Court is concerned, so no harm, no foul, so long as we just simply make sure that it didn't make any difference in this particular case. We'll just say, from here on out, ALJs can only have a single layer of protection. And so I think that goes a long way to explaining why the court didn't directly address the ALJ issue. And frankly, after the oral argument, I'm not at all surprised that this is the way they went. I mean, we didn't.
Can you say more about that? Why the oral argument led you to believe that?
Well, the basic issue here is that for many years, the SEC, if it wanted to impose fines on individuals, was required to go into court. And it was only in 2010 with the financial...
the Dodd-Frank Act? Or
Yes, that they basically gave this option to the SEC to have in-house proceedings, which of course are highly biased, since of course the SEC is going to rule for itself, and it pretty much always does. There was a lot of questioning at the oral argument that seemed to suggest that the justices were highly skeptical of giving the SEC that sort of home court advantage and denying people the right to have jury trials. So this, I think, was the most obvious issue for the court to be basing its decision on, and it's going to be a very far-reaching decision.
Well, I'll admit I was one of the people who thought the court might skirt the Seventh Amendment issue and only decide the other question until oral argument. And I think it was Justice Kavanaugh, if I remember correctly, near the end of Jarkesy's counsel's argument, said, "Well, there is this other issue in there. Do you want to say anything about that?" Almost all the questioning was about the Seventh Amendment. So I thought that was striking. And Michael, I don't know. I think the case was argued at the end of November, if I remember correctly, and it was all the way here at the end of June that we finally get the decision in this case. Why so long? I mean, this was probably waited longer for this case than maybe any other case this term. I haven't looked at the numbers on that, but it's got to be close.
That could be. I mean, it's a big case, and so it may be how consequential the ruling is, and there were several concurring and dissenting opinions as well.
Do you think it's getting underplayed, the significance of compared to some of the other big decisions?
I mean, there have been so many big decisions over the last several weeks that it may be difficult for any of them to get the play that they deserve. But I think this is actually Jarkesy is a very easy case as a matter of text and history. And the only thing that complicated it a little bit is there was some mixed precedent, and I think that you saw that in the opinions. The majority opinion focused a lot on the text and history of the public rights doctrine and the Seventh Amendment. The dissent in its public rights discussion never even mentioned the text or the history, any history prior to 1856. And these are a provision that was ratified in 1791. So the dissent focused exclusively on precedent, and the majority, that was not going to win the day when the precedent was mixed and the text and history is very clear.
Yeah, what about that, Peggy? I was struck that the way that Chief Justice Roberts wrote the decision, it's almost as though, well, we've already decided this. Like this, and we're not breaking any new ground here. I think he said Gran Financiera decides this case, or something like that. I'm not sure that the parties thought it was that cut and dried when the briefing was going on.
Well, I think he does have a point that after Atlas Roofing, the court really then turned around in Gran Financiera and also in Toll and made it clear that Congress couldn't just take a right that had always had a right to a jury trial and somehow transform it by statute into something else. So in that sense, I do think it was a pretty straightforward decision. But the public rights doctrine was a mess, and they had to do a lot to clean that up. And I think going into the history of the adoption of the Seventh Amendment, it does that work for them because it is a constitutional amendment. That's the most troubling thing to me about the dissent. They keep saying this is a policy decision that should be left to the to Congress.
Yeah.
It's not a policy decision. No constitutional right is a policy decision. A constitutional right is a promise that is made to the American people that not even Congress can take that away from you. And that fundamental disagreement between the dissent and the majority and concurring opinions is striking and important, and I think they are literally talking different languages.
Yeah, I want to come back to that in a minute. But Rich, I wanted to ask you, anything surprising here in terms of is there an extension of Toll or Gran Financiera, or do you think, is the Chief Justice underplaying this, or does this really flow directly from what the court has already said in the past about these kinds of cases?
Well, one of the points that Justice Sotomayor makes in her dissent is that Gran Financiera, for example, did not involve the government. It was a bankruptcy case, and it was a participant, a private party in a bankruptcy proceeding who was complaining about the lack of a jury trial. And what Sotomayor said is, so really the public rights doctrine shouldn't arise there because it's not a case involving the government. But when it's the government involved, we ought to be respecting the right of the government to decide how best to order these proceedings. And of course, as she pointed out, Congress explicitly permitted these sorts of administrative proceedings. I think what she overlooks is that, yes, so cases like Gran Financiera are easily distinguishable if you want to distinguish them.
But that was before the Dodd-Frank Act, for example.
Right, but I think more importantly, it totally ignores the constitutional history, that the whole reason for the Seventh Amendment was in reaction to the history of British courts in Vice Admiralty in the period before the American Revolution, where the British government said, gee, these juries in America, they're not going to vote to convict John Hancock and Samuel Adams of treason. So the best way to do it is we've got these Vice Admiralty courts where we can do away with juries and we can have the trials take place in Halifax, and that's an easy way to shut them away. And if you accept that history of the Seventh Amendment, it would seem to me that the Seventh Amendment rationale applies even more strongly when it is the federal government that's trying to impose hundreds of thousands of dollars or millions of dollars of fines on alleged violators of the securities laws than it is, say, in a bankruptcy court proceeding.
What about that history, Michael, that the Chief Justice lays out, and the fact that jury trial rights aren't just mentioned in the Seventh Amendment? They were one of the things in the Bill of Rights that's actually in the original Constitution itself. So apparently a right that meant quite a bit to the founders.
Yeah, I think that's right. And honestly, like, I think most of the time everyone gets this. So like, there's really not too much debate about what the Seventh Amendment actually says and what some of these other constitutional provisions actually say. The really only reason that the SEC
What does it
had
say for our non-lawyer audience, the Seventh Amendment?
The Seventh Amendment preserves the jury trial right in suits at common law. And so...
In matters over $20, right?
Yes, yes.
Those are 17, what, $91 or $89? I don't know. It's a little more than-
I'm sure that there are law professors arguing about how to count to $20 there, so the Seventh Amendment inquiry doctrinally has proceeded in two steps. First, determine whether this suit is a suit at common law, or if it's rather an equitable action. In this case, that wasn't really disputed because the SEC was seeking civil money penalties, and so pretty obviously a suit at common law. The case really came down to the public rights doctrine, and the public rights doctrine is something that if you ask most Americans, what is the public rights doctrine, they'd have no idea what you're talking about.
Well, because it's not in the Constitution.
If you
asked,
if you asked most Supreme Court litigators, what is the public rights doctrine doctrinally, they would have no idea what you're talking about either, or they would know what you're talking about, but they wouldn't know what it is. And the Supreme Court justices have not really known what it is exactly either doctrinally. So as the Supreme Court has recognized itself, its cases are kind of all over the map when they have tried to define the public rights doctrine. But historically, it's actually pretty straightforward. And as Peggy pointed out earlier, it actually goes to a few different provisions of the Constitution. So Article 3, also the Due Process Clause. So historically, the distinction between public rights and private rights, Professor Caleb Nelson has laid this out in an article in 2007. Public rights are rights that do not exist in a state of nature. They're created by the government. So private rights exist in a state of nature. Those quintessentially are the rights to life, liberty, and property. And so the idea is that in a state of nature, you have these rights. The rights to life, liberty, and property are not created by Congress. They existed before Congress existed. In contrast, a typical example of a public right is Social Security. No one thinks that in a state of nature you have a right to Social Security benefits. And so historically, the distinction between public rights and private rights has meant that the executive branch can deprive, the federal government can deprive Americans of public rights outside of judicial process, but cannot deprive Americans of private rights outside of judicial process. And that's not really disputed. There's one law professor who tried to unsettle this consensus a couple years ago, but he basically agrees with everyone else that this is the way that the public rights, private rights distinction works. And the really important point is that the doctrine is actually about the deprivation rather than the government interest that's being pursued. So as a matter of text and history, what matters is whether the American is being deprived of life, liberty, or property. It doesn't matter what the interest is on the other side. So the easiest way to see this is with criminal prosecution, you have a very important government interest on one side. If the public rights doctrine meant that the government interest is what mattered, criminal prosecutions would involve public rights, and you could have them and hold them in administrative tribunals. No one thinks it actually works that way. The reason is because it doesn't matter what the government interest is on the other side. What matters is actually the deprivation. In a criminal case, the person is, the American is being deprived of life or liberty. So this is not really disputed. There's scholars across the board, a Yale Law Journal article from a couple years ago, commentators who otherwise are with the Jarkesy dissent pointed out that no one at the founding would have thought that that the government could deprive Americans of their right to property outside of judicial process. And again, the dissent never even tried to defend its position on any text or history from before 1856. And so like I said, it was really an easy case, I think, as a matter of text and history, and I think that's why the.
Well, let me pause there, and Peggy. So it might be the case that the dissent doesn't try to defend it based on text and history, but the SEC had contended, as the majority says, and this is a quote, that because Congress created new statutory obligations, imposed civil penalties for their violation, and then committed to an administrative agency the function of deciding whether a violation had in fact occurred, that was enough reason for there not to be jury trial rights here. And I do think the dissent buys into that. That seems like a scary world to live in, that if, as long as Congress creates a new violation and assigns it to an agency, you lose your jury trial rights. Fortunately, the majority didn't go along with that.
Yeah, to expand on Michael's point, not just scholars objected to that reading of public and private rights, but at the time, and this is pointed out by Justice Gorsuch in his concurrence, Justice Robert Jackson and Roscoe Pound both were concerned about the tendency of administrative agencies to blur prosecutor, judge, and jury. And so even at the time these new rights, in this case, the securities laws of 33 and 34 were adopted, you had one of the most prominent Supreme Court justices and Roscoe Pound himself concerned that agencies would try to blur those distinctions. So
I should have had our prosecutor, judge, and jury mugs out here instead of the bottled water.
Oh, well, and that goes to the dissent's, to me, astonishing turning the whole idea of separation of powers on its head. They accuse the majority of ignoring the separation of powers and combining these powers, and that just not conceivably correct. It is obvious that here what you have is the executive branch bringing the charges, sometimes defining the charges, bringing the charges, adjudicating the charges, and assessing penalties on the charges without any participation by a jury. If that's not blended powers, I don't know what is. And the idea that somehow the majority opinion does that is astonishing.
Go ahead, Rich.
One of the things I found interesting was how strenuously the dissent dissented. I mean, they really, Justice Sotomayor read at length from her dissent on the bench, and the dissenting opinion is by far the longest of the opinions. And I think that the people who subscribe to the dissenting opinion look upon the decision as a major attack on the administrative state. But I think one of the major problems here is the use of the term public rights, because generally we don't think of the government as having rights. We normally think of the government as having power, and we focused on that issue in our amicus brief in the case.
And individuals have rights against the government.
Right, and so that, yes, Social Security is an example where maybe the individuals don't have those rights except for what's given them by statute, and therefore you don't have a right to a jury trial in a Social Security disability case. But many of the decisions that Sotomayor was relying on really were cases of government power, where the special exceptions have been made, where government power can trump jury trial rights. An 1856 decision was the first one that recognized this. And what it said was, when you have a tax collector who's working for the federal government and he absconds with the taxes that he was supposed to turn over, the government can go right into administrative proceeding and seize those assets from the absconding tax collector.
Its own employee.
Right, and so throughout history there have been certain exceptions where the government power doctrine has been applied to allow the government to step in and act without having a jury. And some of the other areas where this is permitted is immigration, where the power of Congress over immigration has always been thought to be very plenary. And if the government says we don't want to give jury trial rights to somebody who is trying to assert the right to immigrate, if the government does not want to provide jury trial rights in certain other specialized areas, particularly having to do with tariffs, we're going to make those exceptions. But the basic right of an individual to be protected against massive fines from the government has never been among those exceptions. And while the Atlas Roofing case in 1978 came pretty close to saying that, as Justice Roberts pointed out, Atlas Roofing was perhaps to a certain extent already overruled by the Grand Financiero decision 10 years later. In fact, Justice White, who was, I believe, the author of the Atlas Roofing case, claimed in dissent in Grand Financiero, "You're overruling my precedent." So I think that if you recognize that the exceptions that we create are really exceptions involving extraordinary government power as opposed to any right that the public has to seize the assets of somebody who allegedly committed fraud, I think it's a much clearer understanding of what we're talking about.
What about that, Michael? Is Atlas Roofing overruled now? Or was it already? Much to everyone's maybe surprise back, 30 years ago? When was Grand Financiero? Yeah, is Atlas Roofing overruled?
Yeah, it is certainly not the case in the very best standing. Whether it's overruled or not, I think is an open question. But Justice White thought that it was, I think he said
1987.
Overruled or severely limited in 1987, and the Jarkesy majority pointed that out. The Jarkesy majority also clearly did not think that Atlas Roofing is a well-reasoned opinion. It pointed out that its definition of public rights is circular. Atlas Roofing had defined public rights as the public rights doctrine as involving cases that involve public rights or something like that. So it's a very circular non-definition of public rights. And if you read the opinion and some of the other opinions from the 1970s and 1980s on the public rights doctrine, they are saying things that the current Supreme Court, all 9 justices, would sort of grimace at least, I think, such as we have to balance Article 3 against the legislative responsibilities of Congress. That's something that I think all 9 justices would say that's not how we do things. We don't balance constitutional text against other things. Constitutional text controls. There's another opinion from the 1980s that asked whether Congress's departure from Article 3 requirements was justified. So again, this is just not how we look at constitutional text these days. And so I think that that's partly what was animating the Jarkesy court's treatment of Atlas Roofing. In addition to, as the court pointed out, there's been just immense scholarly criticism of Atlas Roofing across the board. Sure. From people kind of on all sides who don't think it was a well-reasoned decision. So it may or may not be overruled, but it's certainly not I wouldn't say the very best case that a litigant could cite moving forward.
So let me clean that up. Toll was 1987, Grand Financiero was 1989. But Peggy, if Grand Financiero was a course correction from Atlas Roofing, how did everyone miss that for over 20 years?
Well, I think because
30 years, excuse me.
Well, for one reason, which shows up in the dissent, which is the dissent seems to be delighted that Congress enacted over 200 statutes with that mechanism in there of this juryless, courtless resolution of any claims the government might bring. And so you have the growth of the administrative state. And one of the things that I think the dissent is trying to do by citing to those is to say somehow, a whole set of laws. Those laws aren't set aside. All it means is if you're charged under those laws, you go to court, just as SEC defendants used to go to court before Dodd-Frank. There's nothing, the press, especially about this decision, is gravely dishonest. It says, oh, well, you're taking away enforcement powers and laws that the SEC can use to catch fraudsters. Not true. There's no change in the law, no change in the remedies. It's just where the case gets decided pursuant to the promise made in the Seventh Amendment. One of the distinctive things about Justice Gorsuch's concurrence, he uses the word promise 10 times. And he talks about the Seventh Amendment being a promise to people organizing under this Constitution that they would not be dragged before vice admiral courts in distant locations and have their life, liberty, or property at stake. And this decision is a fulfillment of that promise and no more. It doesn't take away laws. It doesn't vacate laws. It just tells you you have to decide these in real courts where you have procedural and other protections.
I would just add, you asked how did we all miss the overruling of Atlas Roofing 30 years ago? It might be partly because NCLA didn't exist 30 years ago.
That might be right. That might be right.
I have a feeling someone might have noticed.
Yeah.
I think an important point that can't be overlooked is how difficult it was for people like Mr. Jarkesy to raise this issue. He was in the courts for more than a decade. The problem was a terrible doctrine that said you can raise these kind of constitutional issues before the administrative law judge, but of course, the administrative law judge is not going to say that his process is unconstitutional, so you lose, and then you have to go through the entire gauntlet of all the various administrative appeals, which in his case took more than 10 years, and only then was he allowed to get into federal court to raise this constitutional issue. Most people aren't going to spend that time. They'll say, rather than spending $300,000 in attorney fees, I'll pay the fine and move on. And I think we need to recognize the woman sitting next to me who, in a case called Cochran that went up to the Supreme Court 2 years ago, Peggy finally prevailed on the issue that no, when you have these sorts of constitutional claims that are separate from the merits of the agency's claim, you have a right to go into court immediately. And Peggy actually has been in the Jarkesy case from the ground floor because, of course, Jarkesy was among the people who was caught up in the old rule. He lost in the D.C. Circuit back in about 2009, I think. 14, and thanks to Peggy's Cochran case, that D.C. Circuit decision was overruled. But from the very beginning, Peggy was kind of providing guidance to the Jarkesy attorneys so that while our role was nominally as an amicus, from the very beginning, thanks to Peggy, we have been involved in the Jarkesy case in guiding the framing of the issues. And they obviously had very good and persistent attorneys who were there in the Texas court, but I don't think we should overlook Peggy's role in bringing this case along as well.
Yeah, I agree. Michelle Cochran and George Jarkesy, both from Texas, both in the Fifth Circuit, both had the same objection to the extra layers of protection from removal for ALJs at the SEC. And George Jarkesy, along with five other, the D.C. Circuit in Jarkesy's case, along with five other circuits, had gone the other way until you were able to prevail on that issue in front of the en banc Fifth Circuit and then at the Supreme Court.
To me, it's kind of interesting that the court is silent about that entire episode because Justice Kagan wrote the unanimous opinion overturning the denial of a court venue to George Jarkesy.
Right. So he gets a court venue, but not a jury.
It was six circuits that got overruled unanimously by the Supreme Court. That doesn't get mentioned in here, and I, in particular, think that some of the footnotes in the dissent are a little troubling on that account. And by the way, Justice Kavanaugh was on the panel that tossed George Jarkesy out from the D.C. Circuit in 2014. So it seems to me there are a couple of justices who, might have since adopted a different rule of his constitutional right. But that's not even mentioned or acknowledged.
One thing that is mentioned and acknowledged in the majority decision is the very shabby way that the SEC operated not only in the Jarkesy proceeding, but also in the proceeding involving Ms. Cochran and at least 40 or 50 other cases where supposedly we have these federal bureaucrats who are going to work very fairly, and for example, they promised to keep the ALJs and their fact-finding portion of the agency separate from the prosecutors, but it later came out that in fact they were sharing information and the prosecutors were reading the internal memos being written by the judicial branch of the SEC. And when that information finally came out, that was what eventually led to all charges against Ms. Cochran being dropped after she won on her procedural issue in the Supreme Court. And so if
I believe
you are
42 total cases were dropped by the SEC. They might have dropped Jarkesy's case too if they could have, but I think the Solicitor General was, no, we're not dropping a case that we've already taken to the Supreme Court. That's not going to happen. But they dropped every other pending enforcement action to prevent discovery on this issue, I think, of this so-called control deficiency they had.
So when people such as the dissenters talk about how it really is just fine and efficient to allow these cases to proceed administratively, I think these 42 cases are Exhibit A about how maybe they're not so fair, and that's why we want an independent judiciary and we want juries that will allow the issues to be fully vetted and to make sure that the proceedings are fair and comply with due process.
Yeah, I mean, I think they're exhibits A through Z and double A through whatever that is, double Q or something, right? Those 42 cases.
I think that the control deficiency, which is the sharing of files, was a pretext, though, and an excuse, because the real thing they didn't want to see happen was for the actual constitutional issues to come before the court. I think those were dismissed, all of those cases, because they were all open pending proceedings. And I don't think this is a lesson in standing up to an agency. If you really challenge them on constitutional grounds, maybe they don't want to have that test taken in a real court of law.
Yeah, that's a good point. So I was chided after one of our recent luncheon laws that I never actually asked the question of the panel that was in the question for the luncheon law. So I don't want to make that mistake today. So Michael, how far does the new ruling reach?
So I think that what was really interesting to me about the opinion is that it said that civil penalties are a remedy that require an Article 3 judge and jury. And it said that several times, actually. And it said that civil penalties are punitive. And so if you have a punitive remedy like this, it wasn't, majority pointed out that maybe it would be different if this was like a restorative remedy where
restitution or something.
Right, exactly. But
because that could be equity, right?
Mm-hmm.
Arguably.
Mm-hmm. But civil money penalties as a remedy, the majority said several times, can only be decided in a court of law. And so that to me seems to be a pretty sweeping holding with pretty sweeping implications for obviously not just the SEC, but many other agencies.
Yeah, so bright line and sweeping. Rich, I'll go to you next. How far does this ruling reach?
Well,
does it go outside the SEC?
I think that this decision shouldn't be read just in isolation. The Supreme Court addressed several administrative law issues this term. In addition to this, perhaps most prominently NCLA's victory in the Relentless and Loper-Bright case, where the court struck down the Chevron doctrine. And I think that the combination of all of these decisions makes it clear that the courts are not going to allow federal administrative agencies to run roughshod over constitutional rights, that they're not going to necessarily close down the administrative state, but they're going to make sure that that administrative agencies comply with constitutional law.
Yeah, absolutely. Peggy, I'll give you a chance to answer that question as well. How far does this reach? Does it go beyond fraud cases? Does it go beyond just the SEC as an agency?
Well, I think the fact that they say that Congress does not have the power to assign judicial power to any other branch means that, in fact, it goes quite far.
Yeah.
And I think that there are the public rights exceptions of taxation and benefits and customs and those clearly defined exceptions. But as Justice Gorsuch says to the dissent, why would we have bothered under public rights to have made these fine distinctions if they didn't, in fact, define the world in which of equity and admiralty, et cetera, in which those rights can be taken away. Otherwise, you not only have a right to a jury, but you have a right to an Article III court and an independent adjudicator. And I think that's a huge holding. I think it's greatly significant because not everyone will want a jury trial that's charged, but they still get an Article III court. And I think that's really a wonderful and little understood aspect of this decision.
Well, and very helpful for the dissent to say that there's over 200 statutes that this applies to, I think.
And I had a long string cite.
Yeah. Well, there's also a long string cite to Collins, Arthrex, Seal of Law, Free Enterprise Fund as a disturbing trend, but that's the law.
Those are all our victories. That's not a disturbing trend. That's justice being restored to America.
Yeah. Right.
Well, this is really a debate that has been going on, I think, since the days of Woodrow Wilson, where I think that on the one hand, groups like NCLA have argued that the power that we most need to be fearful of is excessive government power. And those on the other side will argue, no, it's the power of these strong forces in the business community who, unless we have the government that controls them, they'll run roughshod over the public benefit. And that's a fight that has been going on for at least 100 years, and I suspect it will continue to go on. But I think that this term in the Supreme Court was a very encouraging move in the correct direction. Because if you look at who the clients are that the government is going after in these cases, we're not talking about going after Microsoft or the large corporations who can take care of themselves. They're small individuals like Michelle Cochran and other of NCLA's clients who don't have the wherewithal to take on the federal government. And that's why I think NCLA thinks it's very important that we have a system of government that protects the rights of those small individuals.
Well, let's throw it open to questions from the audience now. But I agree with you, Rich. I've never understood this idea that big business is the bigger threat than the government. You can choose to do business or not do business with just about any company out there. You can't choose or not choose to do business with the U.S. government. If they take an interest in you, you're obligated to be involved in that proceeding. So, John?
It strikes me that the SEC can always go to federal court, as they did since before 2010. They had to go to federal court for most of these things, and you could have a jury right. All those 200 other agencies, I believe most of them don't have an option to go to federal court in the statute. How are they going to get juries? And if they can't get juries, what are they going to do?
Well, I throw it to any one of you, but I mean, I think what you were saying, Peggy, is they can't have a jury in the agency anyway because the court said you have to be in an Article III court, and
Right.
These agency tribunals aren't Article III courts, right?
Precisely. So I think it's a vesting issue that in those statutes, Congress did not have the power to, because it has no judicial power to assign that power to an agency or its adjudication system under the executive branch.
What we need to be clear about is the government is not left without powers. What they can't do is impose large fines administratively. But for example, many of the agencies have power to for injunctive power. I mean, basically the EPA and the FDA and other large agencies, FTC regularly adopt rules that they can enforce administratively. All they can't do is to impose fines on their own. If they want to hold somebody in contempt of court, for example, if they're not following the agency's order, I don't believe there's any agency that does not have the power to go into court for contempt proceedings if that's what's necessary to enforce their injunctive power.
Just one follow-up. What do you think about debarment? Is that a private right or a public right?
For Boeing or other companies?
The debarment power is a very frightening power that the government uses, and I think it does impair your rights to contract and enter into, and the way it's used when you're debarred, other companies are also forbidden to do business with you. And so I think when you get to that kind of a power and that reach, I think debarment would not be appropriate in administrative proceedings.
It doesn't seem like an equitable remedy. I mean,
No.
I think Philip Hamburger's position has been that you have a jury trial right to anything that isn't admiralty or isn't equity, and
Right.
those are the only two things that are exempt. Everything else you get the jury trial right for. I don't know if this decision sweeps that far or not, but it sure comes close if it doesn't.
Well, I certainly don't think anybody has a constitutional right to contract with the government. So if what you're talking about is being barred from the right to have a government contract, I'm not sure you would have a jury trial right for anything like that.
But it's impairing your right for others to contract with you because you are a debarred company. So
As a subcontractor,
yeah,
for
Right,
example.
and
yeah.
therefore, if they debar you from doing it, you always have a right to appeal from the administrative proceeding. But it is an equitable proceeding, and so I don't think that the Seventh Amendment would come into that. Now, maybe some of the factual findings would be judicial in nature, and therefore, under Article 3, you would have a right to the fact finding for that in the federal courts. But I don't think that because of its equitable nature, you would have any jury trial right under the Seventh Amendment.
Other questions?
So
we have somebody online?
The chat has exploded with questions. There are literally like 30 or 40 questions. They're all some variety of, but what about this agency? Well, what about that agency? What about state agencies? So the first question is, hey, does this go beyond just the federal government? Is this also something that might come to the rescue of folks that are being similarly hounded by state level agencies?
Most state constitutions have jury trial provisions. So it's certainly something to take into consideration.
Has the Seventh Amendment been incorporated against the states? I don't know the answer to that.
I don't either. But the state jury trial protections, I think, are all of the states have them. And so you would have to look at the law, applicable to those state jury trial rights.
One interesting feature of this case is that the SEC, of course, always had the right, if it wanted a jury trial, to get it by going into federal court. So they were denying that same right to individuals who might want a jury trial because the SEC could do it administratively and thereby deny the right. There are at least 3 or 4 states that have issued decisions to say that violates equal protection provisions under state law, that you may not have a system where only the government decides whether to have a jury trial right within this state.
And I would just add again that this case was pleaded as a Seventh Amendment case, but because the case really turns on the public rights doctrine, it actually has equal implications for Article 3 and I think the due process clause, because the reason that you might not get Article 3 process in a case like this was because of the public rights doctrine. And so whether the public rights doctrine applies really is going to determine the Article 3 issue and due process issue as well. And so the due process clause of the 14th Amendment obviously applies against the states. So I think that's one fact that's relevant to that question.
I'd agree.
One particular agency, of course, comes to mind is OSHA, because that was the agency at issue in the Atlas roofing case. And to the extent that people might think that Atlas Roofing has been overruled, I think it would be wise of litigants to raise that issue in any action brought by OSHA, where it's trying to impose large fines for having unsafe working conditions.
Well, that's very interesting too, because there was a non-delegation case that the court denied cert on right at the end of the term that had been relisted multiple times, I think. So it was a little surprising that they denied cert in that case, and I wonder if the court maybe thinks that Jarkesy has supplied part of the solution, and they don't need to reach the non-delegation question for OSHA purposes. So that would be interesting. More questions from the online audience, Clay?
Absolutely. So speaking of these fines, the audience wants to know, can they sue to vacate fines that have already happened in an unconstitutional violation of their right to a jury trial? There's a Third Circuit case, FAA case, Exalta v. FAA, where it's been argued that Jarkesy now requires the court to vacate civil penalty issued by Department of Transportation or FAA. Are we going to look at penalties being vacated and reversed? Should everyone line up at the courthouse to get their money back?
Well, before I throw that to the panelists, let me just say NCLA is not providing you legal advice on that question. Talk to your attorney. But if you want to jump in with that caveat, go
I
ahead.
would say that if you raised the issue of failure to provide a jury trial at the time that you were initially before the agency and you lost on the issue, you might have a plausible case for reopening a case that is closed. I think most people, however, didn't raise the issue, and I think you would be in serious danger of being held to have forfeited the issue if you didn't raise it before. So it might be very difficult to bring those kind of after-the-fact challenges.
So there is one other online question.
Please, go ahead.
And that is in a situation where someone has effectively consented maybe to the administrative process by licensing, maybe as an SEC, a corporation licensing to be registered. Is there a situation where people can have given up, have waived their Seventh Amendment right, or has the court's decision basically made that argument null and void?
Well, I think the licensing is one of those ambiguous areas too, whether that is a privilege the government confers upon you, or whether that's one of the natural rights that you were talking about on the public rights doctrine. So that would be the first question, I think. But to the extent you've consented to a proceeding and it's been resolved, I think it would be very difficult to reopen on these grounds.
Yeah, I think it's maybe the same answer that Rich gave on the forfeit
Right.
issue a moment ago. Go ahead, Michael.
Yeah, I mean, I think in some fact patterns you would have disagreement among justices and scholars on how that would work. So I don't think that there's a perfectly clear answer to that question. Like on whether it's a public right or a private right issue, the Oil States case from a few years ago, there was split among originalist justices on whether the revocation of patent was involved a public right or a private right. Mm-hmm. And so I think that there are definitely also the unconstitutional conditions doctrine could come into play for some of these issues. So I think that there are definitely some open questions in that area.
Well, I want to get final thoughts from each of you, but first, Peggy, I want to come back to you to say what happens to Mr. Jarkesy now?
Well, that's an interesting question. Justice Gorsuch closes his opinion saying the SEC has the ability to go after him in court, but I don't think it does for a variety of reasons, including statute of limitations reasons, including that the SEC itself has conceded that a administrative proceeding does not toll the statute of limitations. So I think Gorsuch's point on that was really it could have all along gone after him in federal court. There's no constriction of agency enforcement power involved with this decision. It's just that they went to an unconstitutional tribunal to do so.
Plus, if they do go after him, you can bet your bottom dollar that he's going to seek discovery on the control deficiency issue and find out exactly how much sharing of information was happening between the prosecutors and the ALJs at the SEC.
Yeah, I don't think there's a reasonable prospect that they will do that for the statute of limitations and other reasons.
I think if they're willing to dismiss 42 cases, they're willing to dismiss 43 cases. That would be my that'd be my bet on that. Final thoughts about this case, Rich?
Well, I do think that it's a very broad decision. The fact that it is grounded in the Constitution, say, unlike cases like Chevron that are really much more statutory issues, means that it's not something that Congress can step in and try to reverse in any way. So it's going to have long-lasting implications. However, the court recognizes that there is such a thing as the public rights doctrine, and it sounds as though it's going to continue to recognize it, and it's not just going to be limited to cases of government benefits like Social Security. So there will continue to be litigation about exactly what is a public right. I think the OSHA will be the first test case we see, but there will be other agencies, I'm sure, that will assert that they ought to be admitted within the narrow exception that the court recognized. So there will be plenty of future litigation opportunities that will flesh out the meaning of the decision, but I do think it's going to have a lot of lasting impact.
Michael, final thoughts?
Yeah, I would just say, taking a step back from the Seventh Amendment and public rights doctrine and the specifics of this case, I think this is a really interesting case in terms of the methodology and the way that the Supreme Court thinks about precedent. So as I was suggesting earlier, this was a case where you had some mixed precedent, very clear original meaning, and the case was decided on June 27. On June 21, the Supreme Court decided the Rahimi case. That was a Second Amendment case, and Justice Kavanaugh wrote a concurring opinion where he talked about the interaction of text and history and precedent, and he said that the Constitution's text is the, quote, law of the land. He's quoting the Constitution itself when he said that, and so judges are supposed to be applying the original understanding of the Constitution's text, and also are supposed to respect precedent that comes from Article 3 vesting clause. And so the way that Justice Kavanaugh framed this is when there is precedent that is inconsistent with the original meaning, that's going to affect the breadth that the Supreme Court gives that precedent in future cases. And he said that the original understanding of the Constitution's text should exert a gravitational pull on the court's precedent. And I think that's what happened in this case in Jarkesy. And I think that going forward, I think everyone's on notice that the Supreme Court is not going to be giving broad readings to precedent that is clearly inconsistent with the Constitution's text.
We'll give you the final word, Peggy.
Well, I think that I'm just going to go back to my original point, which this is not just jury trial rights, it's Article 3 court rights. Mm-hmm. And that does solve a lot of problems. It solves the due process problems because you get the federal rules and the federal rules of evidence, and it also takes some of the issues having to do with ALJs and the removal protections, et cetera. And if you understand this, as the court talks about it, as vindicating the right that you are not going to be convicted by the very people charging you, or sometimes even making up a rule under which they charge you and then try you and then convict you and fine you, and then the judicial review that's left after that is essentially meaningless. So I think it is a hugely important decision. It will restore due process and the protections of Article 3 adjudication to Americans in many, many instances.
Absolutely. Well, I thank the audience for joining us and would ask them to join us for more Lunch and Law episodes in the coming weeks. We'll have at least one more as we continue our discussion series on important Supreme Court decisions from the most recent term. If anyone thought administrative law was boring before this last couple of weeks, then you certainly can't say that anymore. I think every administrative law professor in the country is going to have to throw their syllabus out now and start over, because this has been an absolute watershed term for administrative law. the New Civil Liberties Alliance was at the root of a lot of what happened, and we're very excited about it. We'll certainly cover NCLA's huge victory in the Loper Bright Relentless case at a future luncheon law. But for now, on behalf of NCLA and our esteemed panel, I want to thank you all for attending this luncheon law event entitled SCOTUS Restores the Seventh Amendment, and I'll have to admit it now, and Article 3, right to a jury trial. How far does the new ruling reach? Would you please join me in thanking our panel?